there was a huge, huge problem in the law as it relates to this subject many years ago when the whole issue of .coms came about. Because there were people out there who were going out who had the idea and the foresight of knowing that getting these addresses were going to have value. And so they would go run out and just think about, for example, what the value is, www.lawyer.com. I mean, my God, if you could own that site, just think about how valuable it would be. And somebody went out and got it. And what happened is Martindale and Hubbell, which is the large legal referral source throughout the world, has now gotten a license from that individual who got the domain name. And you think to yourself, my God, well, what are we going to do about it? Well, the law really ran like lightning to try to catch up with this thing because they said, well, listen, the word lawyer is not something that you can trademark. Lawyer is a generic word. If I say to you, what is on top of most tables, that plastic laminate, you'd probably tell me, well, that's Formica that's on top of that. Well, Formica has been so broadly used that it's become generic. At one time, for example, the word aspirin was a trademark of a particular manufacturer. Now, of course, it's generic. It's used by everybody else. Escalator, elevator are another examples of words that at one time were owned by one manufacturer. And now, because it's so broadly used, it's now lost its individuality. Can anybody in the audience think about something that we use, a name that we use for a product that almost has become its very name? Go ahead.
Q-tip.
Q-tip, perfect example. Kleenex, another perfect example. Pardon me?
Vaseline.
Vaseline. The amazing part about it is that we have, as a society, come to a point where these trademarks have in actuality become the name of the product. You have probably seen, I'm sure you have, and if you haven't, next time it's on television, I know you'll think about it. Who doesn't like English muffins? Everybody likes English muffins. But when they advertise on television, do you notice that Thomas's always says, Thomas's brand English muffins? They want you to differentiate the Thomas's product from everybody else. It's the same thing with thermos. You know, you look at this young lady has a thermos in her hand. We've come to take a look at this, and that item has become generically known as a thermos. Well, thermos has spent a lot of money trying to persuade the world that it's thermos brand. And of course, everybody has had the experience where you've been sitting in your office and somebody has turned around and said, hey, listen, do me a favor, make a Xerox of this. Well, Xerox is somebody's trademark. You're not going ahead and make a Xerox. The Xerox is the manufacturer. And Xerox has spent an awful lot of money trying to dissuade people from using the word Xerox in that fashion. So intellectual property deals with the area in social media. The other category that I want to spend just a few minutes on is that of copyright, because that's where you can get in trouble as well. Copyright protection is interestingly enough, mentioned in the Constitution of the United States. If you go to the Constitution, you will see that one of the protections that is afforded to citizens is that of the intellectual, artistic creativity known as copyright. And the Constitution protects authors and artists from their work. And the reason for that is that the founding fathers, and there unfortunately only were fathers, it's a shame. I wonder how much different the document would have read if there were founding mothers involved as well. But they recognized the fact that in order to encourage creativity, in order to encourage progress, that the people who invested their intellectual abilities into creating new things needed to have a level of protection. And so now in America, unlike the rest of the world necessarily, a person who creates an artistic piece, a person who writes a song, writes a poem, writes a book, draws a picture, takes a photograph, a person who stands up in front of you and is giving you a lecture as I am today, this is my copyright. This is my intellectual property that I'm giving to you today, as is everybody who ever stands in front of a classroom, every teacher, every professor. And that's protected. And that's one of the issues that you have to address when you're dealing with matters of social media, is that in many cases what you're doing is you are lifting, borrowing, copying someone else's work and incorporating it in one way, shape, or form into your own site. Now, let's talk about the actual issues in social media which could present a problem for you. One of the things is that I want you to leave today with some hardcore, practical advice. And the value of it is inversely related to how much you guys are paying me to tell you this. So it's much more valuable than what you've paid to walk into this door today to listen to what's taking place. The first and foremost thing that you need to do in your business is, if you're dealing with social media, if you have employees involving social media, is you absolutely, positively, if you walk out of here and have no other pearl of wisdom, so to speak, it's this one. You need to have a written policy about what your employees can and cannot do regarding social media. Are you going to allow your employees during the course of the workday get on Facebook? Are you going to allow them to be able to email and use the social media networks? Can people participate in Twittering when they're there? Now, this is a philosophical a philosophical decision that the management of every company, large and small, needs to make. How much access are you going to give to your employees? Now, of course, one primary issue is, does it affect productivity? I mean, obviously, if you're out there answering emails or Twittering or on Facebook and responding back and forth, you're obviously not working, and that's a problem. And now I can tell you this much. As an employer, the only thing that you have to enforce that would be a written policy to say that you can or cannot do it. What is very surprising to me is that there are some companies who have tried to come up with a hybrid. And so what they've said is this: you're allowed to use the social media on your breaks and at lunch hour. To me, that's a prescription for disaster, because then, of course, you have employees who are saying, well, I didn't take lunch today, and so I want to use it now or later, or they break it up in the course. I think this is one of those things you have to make a definitive distinction. Are you going to allow your employees to use it? And if you are, then you better make sure that there's a policy in terms of how far they go. Now, here's the problem. What if, during the course of an individual who you've allowed to, let's say, add and post messages on people's walls or whatever, and it's done during the course of the employment, and someone says something which is defamatory. Somebody says something which is offensive to another person. Question is this: is the employer responsible for that? What do you think?
Probably.
The answer is even more than probably. The answer is definitively yes. Especially if you don't have a policy for it. If somebody gets on there and makes a defamatory statement, a statement about somebody else's product or personality, and it's done on company time, and it's done on company, and more importantly, even if it's done on company hardware, although I have to tell you, the use of the company hardware is really not dispositive. It's on company time. If you're paying someone and they're doing something along this line, you are on the hook. If this afternoon, after we speak today, I asked my secretary, as a lawyer, and here we are near a courthouse, I said, listen, I need these papers filed today. I need this lawsuit filed, and would you take it down to the courthouse, and would you file it for me? And, of course, it's part of her job, and she says yes. And while she's driving along the way, she's doing something which she shouldn't be doing, which is maybe putting her makeup on or, answering a text or doing something along that line. She gets into a car accident. Guess who's on the hook? Me, the employer. Because she is on a mission, on a task to satisfy the employer.